This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today I'm excited to welcome Dr. Elliot Fishman. Dr. Fishman is the founder and CEO of Astrina, Inc., a litigation support firm specializing in securities valuation. He's a sought-after expert, a PhD economist, and a published author. Dr. Fishman holds multiple advanced degrees, including a Wharton MBA and a PhD from the University of Pennsylvania. Dr. Fishman, thank you so much for joining me here today.
Oh, it's my pleasure. Thanks for inviting me.
Of course. Let's jump into it. You have decades of experience as an expert witness for the financial sector primarily. Tell me about Astrina, how you first became an expert witness.
Well, the caveat is the financial services sector and the intellectual property sector. So I do securities valuation as well as intellectual property valuation, patents, copyrights, trademarks, as well as options, warrants, derivatives, and so on. How did I get into the field? Well, it was kind of by accident. After my Wall Street career, I was a college professor at New York University, the Stern School of Business, and then Stevens Institute of Technology. During that 7-year stint as a college professor, I was asked by a colleague, actually a friend of a friend from a major law firm, an Am Law 50 firm, who was doing some analysis on a derivative to the Madoff fraud case. It was the largest securities fraud case in U.S. history. And they had hired some experts from the big firms. This is a derivative to the Madoff case. It was the reallocation of proceeds after the bankruptcy hearing. And so this attorney and their economist friend were not really happy with the results that their so-called experts were providing for them, even though they came from the big firms. They could not really look at it the same way I was able to, as both a college professor and having practiced on the street. Portfolio economics is not merely an accounting exercise. And it's not merely a corporate finance exercise. You have to really understand how the securities are issued, to whom they are issued, and the way they are issued to apply the appropriate discounts. Well, to make a long story short, I stumbled into it. I was asked just to take a look at someone else's report for a few hours, and I put my college professor hat on and my red pen, and I found some issues with the way the report read and suggested a different way of looking at it. Before I knew it, I had been asked to replace the big firm that had been consulting on the case for many hundreds of hours. And I wound up writing my own independent expert report and testifying at deposition on the case.
On your first engagement, you were testifying.
On my first engagement. And I had no idea anything about the field, but I was told during and after the fact by counsel that I was pretty good at it, and I might consider it as a new career. So I was a college professor at the time, and I kind of stumbled into it.
That's really interesting. So you went into it, really hit the ground running. How was the preparation that first time out? Did you feel prepared and ready to be an expert witness for such a big case?
Well, preparation is sort of a double-edged sword. One of the qualities I've learned over the years in being an expert witness is not to put the hat on as an expert witness, not to jump out there as a hired gun and think you know everything. It's just, if you're qualified for a case, you show up and you apply your trade and you run your numbers and you do good work, just like you were writing a paper for a published journal, and you present yourself authentically. So there was nothing really to prepare. I was just asked a series of questions and I applied my learning.
That's really interesting. I've heard a lot of stories about people, who felt that they could have used a little bit more preparation, either some mock cross-examination, somebody who had never really been in a courtroom setting before, they kind of weren't ready for the hot seat, or weren't sure what goes into a report, or, how how to answer questions. Where does my expertise begin and end? A lot of attorneys give the advice not to answer anything other than exactly what is asked. Don't give any extra information, things like that. But it sounds like you were already pretty ready for it, and you didn't need a whole lot of coaching. Is that right?
Well, it's funny you say the attorneys always try to coach. It's just in their blood. They want the case to unwind a certain way and certain answers to go on the record in a certain order. But it all sounds so terribly scripted. Of course, one has to have their wits about them and not and make contradictory remarks on the statement or anything ambiguous that can be torn apart on cross. But again, it's I think the main goal of an expert is to be authentic and not to practice out of his trade. If I don't know the answer, I'll just say I don't know the answer. And that's perfectly acceptable in a deposition or a courtroom. And
Sure.
it engenders the authenticity of this testimony. And that's ultimately what a judge and jury are looking for. And that's also what unsettles the other side when the expert's not trying to know everything or pretend everything. I mean, gosh, 20% of the time in a deposition, I'll concede that the other side's right. I mean, every case is perfect.
Sure.
But why not? Because we're not. At the end of the day, an expert is not really advocating his client's position. And I think this is very important for new experts and maybe new attorneys to understand that we have an ethical obligation, and under the rules of civil procedure, we have a professional obligation to be objective. And I put in my engagement letter, in my retainer letter, that I may obtain findings that are helpful to your client, neutral to your client, or even hurtful to your client. But at the end of the day, the expert is objective, and his ultimate responsibility is to the court, not to his client.
Let's unpack some of that a little bit. I want to back up to being an expert in the first place. So what does that mean in your industry, but also more broadly? What does it mean to be an expert, and expert enough to be able to take cases and generally have the enough knowledge to be able to properly represent the facts of the case? Do you ever find yourself at the last minute needing to brush up on something or learning something new because you're in a venue that you haven't been to before or anything like that?
Well, one should be learning throughout his or her whole career. So brushing up is just what you do on a monthly basis. And
Sure.
When a certain case is presented, it gives me the opportunity to learn the literature again. I should not be learning the literature fresh, or that's not a good case for me. Fortunately, I've taught finance at major universities. I've taught finance at the graduate level, including some complex topics. So a lot of stuff out there I've seen before in the academic literature, and a lot of stuff out there I've seen practicing on Wall Street as a private equity manager, as a venture capitalist, as a restructuring and M&A guy.
Do you recommend things like attending conferences or even speaking at conferences or continuing education?
Well, about 10 years ago, I decided that I was never going to attend a conference unless I was going to speak or be on the panel. And that doesn't, I'm not trying to be conceited. It's just such a time sink. And
Sure.
Also, it's sort of a double-edged sword to collect a lot of business cards and meet people, because I've trouble enough staying in touch with my existing network. And it's kind of disrespectful to make new professional acquaintances and not follow up in a meaningful manner. So, conferences isn't really where I go to brush up. I'll give some CEUs. I don't take CEUs, but the various professional societies will ask me if I'll give a course to offer people CEUs.
Is that because of your unique position? Well, not unique, but because of your position of having taught this subject a lot and also having been doing this for a very long time? In other words, what would you recommend to a newer expert to maintain their expertise and to continue to grow if they don't have quite the storied career that you do, Dr. Fishman?
Oh, now I'm blushing. This is an audio interview. You can't see me blush. I don't know if I have a storied career, but I have a long career and I've worked hard over the years. I think for younger experts, they just have to do their work. They have to get their credentials. If they don't have a PhD, get other letters after their name. There's enough professional certifications, whether it's a CFA or any of the CPA designations. Conferences are helpful, but it's a lot of career networking going on. I find them to be intellectually light. I'd recommend a younger expert go for one of the letters after their names, and like a CFA, because that demonstrates substantive expertise. And I'll tell you, the MBA and the CPA are kind of light credentials. I don't mean to be offensive to anybody who's listening to that and are practicing experts with just an MBA, but in deposition, you just get torn apart. The MBA finance curriculum just is not deep enough to answer many of these questions of the complex securities cases. You really do need the PhD background or many years on Wall Street to know how the securities trade and how they should be valued.
Do you think it's important to have a niche, an expertise niche? So something, not just finance, but something very specific within finance that maybe there aren't quite as many experts?
Well, yes and no. I mean, sure, everybody wants the person who knows the ins and outs of convertible bonds and has only done that instrument their whole career. But that limits your opportunity. I don't know how many of those cases are filed per year. You don't want to limit yourself. I would not branch out too far beyond the area of your academic training or your work training.
You had mentioned ethics and how you are bound to tell the objective truth. You are not bound to represent the attorney or the case. You just need to tell the truth. Have you run up against ethical issues during cases frequently, or have you been in the position where you've not accepted a potential engagement that otherwise would have been lucrative because of ethical issues?
I have most definitely turned down assignments because I wasn't sure about either the credibility of the client and or the legitimacy of their case. And I never want to be in a compromised position, personally or professionally, where I am helping an attorney argue something which I don't sincerely believe in. Now, it's not entirely evident in the beginning of a case until you go through the deposition files and read all the paperwork and the interrogatories about who's really on base and who's pushing the envelope. But if from the onset, I would never take on a case where I don't feel good about the client or the legitimacy of the claim.
Has it ever happened to you during a case where you've already taken an engagement and then it turns out that either the attorney is trying to put words in your mouth or get you to talk about something in some very specific manner that you're not comfortable with? And have you ever had to walk out on a case?
I've never walked out on a case, but I've pushed back on counsel pretty hard sometimes.
Do you find that proactive?
By the way, and they've gone back and hired me again, even after I did not take the script. They respect
Is that right?
my professional independence, and it worked out.
Do you find that kind of more proactive approach is best for a newer expert, that you should be pushing back on what the attorney is trying to quote unquote coach you to do or say?
Well, ultimately, you have to live with yourself, and clients will come and go. But if you're compromising your ethics early on in your career, that's not a good path to go down. Then you'll always have that voice in the back of your mind: Am I authentic or not? I don't ever want that voice in my head. And I think young people starting out should keep that in
mind. Have you been the subject to any great amount of oppositional research, or trying to impeach the witness? Have they ever come at you with things like he's not actually an expert, or he's isn't the right person for this, and tried to tear you down from the other side? And how do you deal with situations like
that? Well, I've had Dober challenges, which I've always prevailed on. Everyone has a Dober challenge.
Sure.
Has somebody Googled me or doxed me and tried to come up with stuff that might make me embarrassing on the stand? I mean, I'm like, have at it. It's part of the credentials I hold out, is that my public record is unimpeachable. And I think that's something for younger experts to bear in mind, too. Be careful what you say and post and positions you take in your career, because it can and will be held against you 10, 20, 30 years later. And everything, I mean, there's a perfect memory on the internet now. So
right. Yeah, that's definitely something that's changed. You know, I've heard stories about digging up an old paper that somebody had completely forgotten. There's people with 60, 70, 80-year careers, and you might not know what you wrote 50 years ago on a topic, and having the opposing counsel pull something out and say, didn't you say X, Y, and Z? So is that a situation that you've dealt with at all?
Yeah, well, sure, but it's never been an issue, because, first of all, most of litigation is just a game.
Right.
That the other side's trying to come up with anything and everything they can, even if they're just juggling synonyms to, I had one recently say, you're not an expert in full absorption accounting, because it wasn't in my expert report. And there was a damages case, and it was the difference between two different ways of looking at damages. So the opposing counsel tried to impeach my credentials because I had never published a paper in full absorption accounting. I had used some other term which was absolutely synonymous with it. You just have to understand that a lot of litigation is just a game, and you have to put your armor on, not take any of it personally, and always fall back on your credentials and what you've done. And that gives you the self-confidence to stand up and present your case. That's all anyone can really ask for you.
Of course. Do you tend to know the experts on the other side? Are they people that you're familiar with, that you run in the same circles with?
I've seen some of the same names time and time again, either cases I have written expert reports on or those I've been asked to look at. So there's a handful of large firms which seem to use a handful of people. It's a kind of a small universe for the big cases, experts that are best to opine on the big cases. Do I know any of them personally? No. But do I know the work and kind of the writing style and their thinking style? Yeah, it comes up again and again. And I presume they know mine at this point.
Sure. I was going to ask whether or not these cases affect the interpersonal relationships with, among your not coworkers, but among people that are in the same field. But I guess if you don't really know them personally, then there's not a whole lot of that's going on.
Yeah, we're not running into each other at Starbucks, but if we did, it would be very collegial, cordial.
Sure. Let's pivot to winding up cases. There's something that I like to ask everybody, and I've heard wildly different opinions of this. Do you stay abreast of the case after the portion that's your engagement? Do you continue to monitor who wins the case, and is that something that's important to you at all?
Okay, so during the case, I deliberately stay removed because I never want my testimony on the stand to be influenced, for example, by the deposition or the testimony of the opposing expert.
Interesting.
And unless counsel shows me a motion or a ruling that would be relevant to my expert report, I don't want to see it. Because this goes back to my whole ethic of maintaining absolute neutrality and objectivity, which gives me authenticity on the stand. After the case is settled, sure, I have a curiosity. I'll email the attorney. They'll never give me a copy of the settlement, but if it went to trial, the transcripts or the rulings are all on LexisNexis, and I'll pull them up like everybody else.
Is that something? The flip side of that is winnability a factor when you're deciding on whether to accept the engagement? Not just is your expertise correct, but does it matter to you that you are on the quote unquote correct side of the case that will probably prevail?
It matters that I'm on an ethical side of the case. So
Okay.
it may be a losing side, but as long as the client is behaving ethically, I would not mind. I have no reservations about taking an assignment.
Without
a lot of time, clients win cases just because they've got a bigger war chest. They'll just hire a big law firm for thousands of hours, and they'll throw millions and millions of dollars, and they'll just overwhelm the other side. So the winnability or the winnability is a different word than the veracity of the case. I'll take a veracious a case with veracity, not always a winnable case. It's nice to win, but that's not how I keep score, and that's not how attorneys keep score either.
Sure. Yeah, there's not hash marks. You would never be a public defendant, right? But that's interesting. I've met experts who have said that that's one of their primary concerns is if they're going to win, and they say that's how they get a lot of their business. And then I've had other responses that are more like yours, where it's just as long as you are, like you said, the veracity of the case is the thing that's important.
Look, every plaintiff believes that they're in the right.
Sure.
I mean, they're hiring an attorney and they're hiring experts, and they're not just doing it frivolously.
Without revealing anything that you can't, do you have one or two interesting cases that you can talk about that have either informed or reinforced the manner in which you approach expert witnessing in general, or changed your perspective in some way?
Sure. I'd have to talk about one that's settled. Obviously, I can't talk about the ones I'm presently working on.
Clearly.
There was a big one at the Delaware Chancery Court, which involved registration rights that a private equity firm wasn't really entitled. They floated public securities on a stock, or they floated securities which were not really supposed to be publicly tradable. And so I got a real deep dive into corporate security law and registration rights. And of course, I had come from Wall Street, so I knew how to trade those instruments, and I knew how to float them, and I knew how they should be priced. But the valuation was just the tip of the iceberg for that. And
go on.
Well, ask me the question again, and I'll give you a more precise answer.
Oh, sure. No, I was just going to ask if you had any big takeaways from it. If it changed anything, fundamentally about the way that you perceive cases, or, your overall perspective.
Well, I think that one goes back to what I mentioned just a few minutes ago, that the winnability of the case doesn't always translate to the veracity of the case. In that case, the defendant had lawyered up with, what a team.
Mm-hmm.
And, there was ultimately a settlement. It was confidential, but my client was absolutely in the right, and that could have gone to trial, and we would have prevailed for, I can't disclose the figure, but it's in the hundreds of millions of dollars. But the client didn't have tens of millions of dollars to litigate it. So I think that's a big takeaway, that the big cases have turned into big money. And you cannot expect to win a big case without a big war chest. And it's interesting, this whole area of litigation finance is developing to kind of buttress that, to give people with smaller pockets more rights.
Sure, absolutely. And speaking of the financials, that's a good segue into billing. A lot of people bill a lot of different ways. Do you prefer project-based billing, hourly? Do you take retainers? What do you think the best way for an expert to bill is?
Oh, I'm very traditional. I bill on an hourly basis. I don't bill every hour I work. I don't bill when I have to come up a learning curve, because that's just not fair to the client. But I'll take a retainer up front. And basically the retainer covers everything up until the deposition phase. So for me to become familiar with a case, to do background research, to research and write the expert opinion, the expert report. And then so at that point, the fixed fee stops, because I don't know what's going to be thrown at me after that, whether I'm going to have to write a rebuttal to the other expert reports, how long deposition prep would take, how long the deposition goes on for. So it's an hourly basis subject to a cap up until the deposition, and then the toll starts running.
Sure. And is that what you would probably recommend to other newer experts?
I think, going back again to my core professional practice, I think that's the ethical way to go. Because whether the client is large or small, they want to know what they're in for. They don't want to get hit with a $100,000 bill right up front. And that's what I would recommend to anyone in the field, whether they're just starting out, they're mid-career, or they've been doing it for decades. Cap your fees up to the deposition, and don't charge your clients for all the brush up that you have to do. That's just avaricious.
Before we wrap up, do you have any last advice that you'd like to give to newer experts or attorneys that are working with experts out there?
Yes, actually, something really comes to mind with that question, and that is to persevere. The expert witness game is a marathon. It is not a sprint. I mean, when I was on Wall Street, people right out of business school would kill it the first year or two out, or 5 years out. They'd be involved with an IPO or a flashy hedge fund. This career is nothing like that at all. You're going to have many, many setbacks and many detractors early on in your career. And you're going to get passed over for many assignments where you think you're qualified for. But just keep your name out there, do good work, do some pro bono work if it gets your name in circulation. That's always worthwhile. And over time, people will hear about you and respect you, and they'll come to you. I don't think I've done any outbound marketing in the past 5 or 6 years. I don't need to. It's just, but the brand and the work takes many years to get to build. So
that's sage advice. Thank you so much, Dr. Fishman, for joining me here today.
Oh, it's my pleasure. Thanks for taking the time and allowing me to share.
Of course. And thank you to our listeners for joining us for another discussion at the Roundtable. Cheers.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.